So you educate people by bringing knowledge, facts, information to their attention, not by grabbing them by the throat and trying to stuff it down their throats, because that doesn't work. It's really counterproductive. You're going to find that there are a lot of lay judges out there, especially at the low echelons of the judicial system. Don't hold it too much against them, if they try to run roughshod over you, because these lower court judges think that they're gods. I mean that literally. These guys, and I've seen some real bad examples of that. I mean, they just think that they're appointed by God himself to come down here and rule with a rod of iron. And they'll try to do that. And they'll throw you in jail. And they'll violate your rights. And you need to be attuned to it and help them along. Because if you've got some real judges that are real problems like that, then they need to be taken to task under Title 42, Section 1983, and removed from office. In the meantime, rather than just removing judges from office wholesale, why don't you try educating some of them? We've talked to some judges eyeball to eyeball and taken them to lunch and said, here's our position. I always use this is the closer, as a salesman, I like to have a closing argument. I would say, Judge, it's obvious that you're convinced that my position is incorrect. And if it is incorrect, I would certainly like to get on the right side of the law. Now, either I'm deceived and I've made a grievous error and I do err not understanding the law, or else there is some information that perhaps hasn't come to your attention and that maybe if you knew what I know, it might help the both of us. Would you research this for me, sir, and then when you find out or get the case that points out that my position is wrong, would you let me know right away so that I can get in harmony with the law? Because I want to obey all the laws. Well, I've been doing this for 5 years, and I've never had a judge or a prosecutor yet ever bring me a case and say, Gordon, you do err not understanding the law. And I don't say that because I'm this smart or that I'm, so much more knowledgeable than anybody else. I believe that the reason for that is that I have probably read, and I would say that on a month-to-month basis, that I probably read 10 or 15 Supreme Court cases a month. Now, there are literally thousands, in fact, there may be 1 million or more of these Supreme Court cases. I don't know how many there are. All I know is that when I go into my law library and I look at the U.S. Supreme Court reports, and it goes back to 1797, and I was in the law library today, and I looked at 1885, and there are, well, in 1886 there were 4 volumes, and in 1885 there were 3 or 4. And I look at the books in 1976 and 77, and there's 3 or 4 volumes, and they're 3 times as thick. I mean, in the old days they were 500 or 600 pages. Today they're 1,000 and 2,000 pages per volume. And there's a lot of cases, and there's a lot of information. And I read about 15 a month. That's about 1 every 2 days. And I've been doing that for 5 years, so I've read a lot of Supreme Court cases. And I base what I know upon the Supreme Court, not upon the 4th Judicial District or upon the Supreme Court of the state of Kansas or the Supreme Court of California or anybody else. I try to stick strictly with the people that count. And I contend that the people in Washington count. It isn't that the other lower courts don't count, but they sure don't count when it comes to rights. Because when we're talking about rights and constitutional issues, you might as well get it right from the horse's mouth. And so I try to conduct my life, and I try to conduct everything that I do in accordance with what the Supreme Court has already ruled. It doesn't mean that they may not rule against me. It just means that I think I have about a 99% chance of being right in my conduct and my procedure. I'll give you an illustration of that. I was out in the jail not long ago. My government takes me out and shows me around my county jail about 4 or 5 times a year. I guess it's because they make changes out there and they want to keep me, the citizen, abreast of all of the advances and changes that they make in our local county jail. It's the only assumption I can make because they take me out there so often. And I was out there the other day, and now they used to beat me unconscious and try to take my fingerprints, and I didn't give them, and so that didn't work too well. And so now they don't beat me up or anything like that. What they do now is they charge me with obstructing and delaying an officer in the course of his duties, I think is the way it's worded. And that's okay. And I don't blame them for doing that. I know they've got a job to do, and I know that the deputy, you know, if the sheriff, who is the boss, says you will do this and you will do that, and you will, every time a person comes in here, you will take his fingerprints on these cards, and you will take his photograph, and you will dress him in this orange suit, and you will put him in this cell, and, you know, the workman, you know, is the servant to the master. And so they'll have what they call administrative procedures. Corporations operate with administrative procedures, and sheriff's offices and police departments and all kinds of organizations, you know, operate with administrative procedures. But, you know, I have a real hang-up with administrative procedures. I don't believe for a minute that the administrative procedures of, let's say, Morrison-Knudsen or General Motors or any big corporation supersede the Constitution of the United States. I just don't believe that. If I'm wrong and if I'm in error, would someone please show me what my error is so that I can straighten it out? But what I'm trying to do is to learn and to know and understand the rules. And the rules are the Constitution of the United States, the Constitution of the state of Idaho, and then based upon these two constitutions would be the Supreme Court decisions, that is the top judicial body that interprets or tells us or interpolates or whatever it is they do with this Constitution, and then tells us the way we have to behave. So I'm out in the jail and this guy charges me with this crime because I wouldn't give him my fingerprints. And I suggested to him, sir, Davis versus Mississippi is a fairly recent case decided by the Supreme Court of the United States, and I think it was 1978, and it says that you should get a court order. I'm not convicted for any crime. You simply arrested me and brought me in here. In addition, let me suggest Idaho Code 1948, 12, and 13, which says plainly, if you have the fingerprints and photograph of a subject, of which, sir, I'm not a subject, I'm a citizen, but if you have the photograph and the fingerprints of this person, within 1 year, you don't have to take it again. Here are legal quotations. Let's look at number 4. And I brought this to the very attention of this jailer out here, and I said, we find it intolerable that one constitutional right should have to be surrendered in order to assert another. Simmons versus U.S. 390, U.S. 389, that's a 1968 case. I'm contending that based upon that case called Davis versus Mississippi, that I have a right to my fingerprints, which are my property at the ends of my fingers, and that I would have to give up my Fifth Amendment rights if I voluntarily gave them away. I would be waiving my right to incrimination, self-incrimination. I'm not convicted of a crime. I'm simply arrested, and you've already got my fingerprints in here. You know who charged me with that crime anyway? Yeah, they do that. They do that, I think, out of ignorance. I just don't think that they understand what they're doing. I find it nearly incredible to believe that these guys can be such fools. I just really do. Here's your Supreme Court that says you've got rights under Hale versus Hinkle. I'm an individual, not a corporation. The Fifth Amendment comes into play here. If I gave you my fingerprints and you went out and you used them, you could find other crimes. And I don't have to testify against myself, don't have to give my fingerprints. Now, if you go get my fingerprints off of a glass or something and use it against me, yeah, that's another story. But you can't compel me to give them to you. You can't compel me to tell you something. You can't compel me to give you my records and books. Those are protected. Well, anyway, they don't seem to understand that, and so I guess we're going to have to teach them in the courts how the law works. Now, the essential issue that I'm trying to get to you is that every one of these legal quotations is from the Supreme Court of the United States. These, friends, are the rules of the game. And they're the superior rules of the game. The rules of the game at the sheriff's office are not the rules that this game is played by. I will not play the game by the sheriff's rules because the sheriff's rules are bad rules for me. The good rules for me come from the Supreme Court of the United States, and so there's the game we're going to play, and there's the rules that we're going to use to play the game. I know those rules. Now, if you are going to be successful in the courtroom, you are going to know the rules, or you are not going to be successful. Now, I'm not suggesting that you have to read a Supreme Court case every 2 days. I'm not even telling you that you have to read the rules of criminal procedure or that you have to read Black's Law Dictionary. I don't know and I don't care what you do. I'm telling you that from my observation and my experience, those that are the most successful in the courtroom, those citizens who are able to go into the courtroom and win consistently, are the citizens that take it seriously and they're very interested in they're the kind of people that like to fight and they like to be the contentious combatant. They like to be the belligerent claimant in person, and they just like the excitement and the thrill and the challenge of the courtroom, because let me tell you, when you get into this and you get started, it gets to be it's worse than flying airplanes. You know, when you first started flying airplanes, for those of you that are pilots, you know, you couldn't keep you on the ground. And it gets addicting, you know, like all kinds of hobbies. And that's what happens here. It gets to be addicting. And every victory just adds that much more thrill to the quest and the chase of the game. If your only motive is that I don't want to pay fines, the way I see this is, we have people come in here all the time, you know, every day. And what their real hang-up in life is, they don't like the Idaho plantation. And they don't like their current master. And they want to come to this school, and they like George Gordon, and they want George Gordon to be the new Massa. And they want me, then, because I'm a more benevolent master, and that I'm a nicer guy, and that my taxes aren't so high, and I have these nifty words of wisdom, and they like it, and it just appeals to them for some reason. And they want me, then, to go into the courtroom and solve their problems. They want to hire me. I'm not a lawyer. You can't hire me. I can't practice law because I'm not licensed. I'm not in the union. I can't do that. Okay? All I can do is teach people the law so that they can go do it themselves. You've got to be the belligerent claimant in person. Remember? But that's what we're faced with. And we have these people that are inherently lazy. Got to tell you another little story while I'm on the subject matter. I had a lady that paid me in advance for the entire course. And she took about half the course. We still owe her the balance of the course. Well, the other day she had a problem and she needed to go to court. And so I went to court, and her presentation and her performance was admirable for the level of knowledge and understanding that she had. She did a fine job. The thing that I found that was so objectionable was that whether or not she can win is questionable. It's about the flip of a coin, 50-50. That's her chances. But she paid me about 3 or 4 months ago. She could have finished the course 6 months ago. She could have been much more advanced. She could have walked in there and just knocked them dead and laid them away. All of her opponents, there wasn't a lawyer in there. Her opponents were bureaucrats. It was over a tax matter. And they didn't know the law. In fact, I was just amazed at their abysmal ignorance and lack of knowledge of the subject matter for which they're supposed to know something, and that's the code itself. And it's just that she just knew just maybe a shade more. She was just about equal with her adversary. Now, this is the way it works. The average factory worker out there in Moline, Illinois, when he goes in against a tax auditor or something like that, that tax auditor just has him 10 ways to 1. Just no hope. If he went up against the lawyer would have him 100 ways to 1. Now, if you've got a competent pro se who's read and knows some rules, and he's done a little study, and he knows the rules to the game, or at least some of the rules, he can go in against a tax auditor, and he ought to be able to just lay that tax auditor away every day of the week. And when he goes up against a lawyer, that's about a 50-50 proposition. Once he's got a year and 4 or 5 cases behind him, he should be able to go in and take on any of the 90% of the incompetent lawyers in America and lay them under the table any day of the week. That's any citizen, any factory worker who works in any company in America that has at least an IQ of 100 or 120, if that's average or anywhere near average, should be able to lay any of the incompetent lawyers away, which are 90% of the lawyers, and which represents probably 100% of the lawyers who are in any kind of public service. Because remember, all the lawyers in public service can't make it in private practice. Only the very best of the best are in private practice. When a lawyer is out in private practice paying his bills, at least you could contend that he might be one of the 10%. If he can't even make it in private practice, if he has to work for the government, well, it's obvious that he's in the 90%. Now, here again, I'll cover my tail by saying, yeah, there might be one or two of the 10%ers out there in the government service. I've never seen one. I wouldn't recognize him. I think I'd recognize him if I talked to him. Yeah, that's right. In the lawyers that are in the public service, and remember that the facts and figures come from our Chief Justice of the United States, so don't sit here and say, Gordon's just rambling and flapping his mouth like a coat sleeve in the breeze. It's the Chief Justice of the United States that said 90% of the trial lawyers in America are incompetent. That means that 10% are competent. Well, the 10% that are competent then are in private practice. So in private practice, you might have a competitor. If they're in public practice, you should be able to lay them away. And there now comes a little practice in the courtroom. You've got to take a ticket or two and go in there and argue it. And in order to get into the courtroom and argue it, then you're back to the rules, aren't you? You wouldn't think about going fishing without reading the fishing rules, would you? Or would you think about going flying if you hadn't read the flying manual, if you hadn't looked at the weight and balance data on the airplane, if you didn't have the owner's manual to the airplane? I know I used to fly for a lot of years, and there used to always be a rule that before you could get checked out in the airplane, the instructor would say, well, did you read the the owner's flight manual? That is, what's the stalling speed on this particular airplane, and how does the landing gear react? How fast does it come up and go down? And when the landing gear goes down, how much drag does that add to the airplane? And how much gasoline does it take? And how many hours of engine operating time do we have? And how many gallons does it burn at 70% or 80% or 90% or 100% of power? And how do you set the power setting? All these factors go into flying the airplane. I always went by the rules when I was flying airplanes. I never got into an airplane and said, just sit down, everybody. I'll start the motor and we'll just go. I don't know how many feet of runway it takes to take off until I read the rules, and that's common sense. But yet people that want to take on the government, that want to go into the courtroom, will go in there and they don't want to write. They're just lazy is what it boils down to. I don't want to write a motion. I want to hire you to do it, Mr. Gordon. Oh, and I don't want to learn the rules because that takes a lot of time, effort, and energy. Okay, to people like that, then why don't you just go in and pay the $40 fine? Because you have the mentality of a slave, you have the performance and the actions of a slave. Now why don't you just go in there and serve your master and shut up? And it goes a lot easier on you. The government master isn't going to get real nasty and hard. They just want you to work and serve them. And if you will work and serve your government master, you won't have too many problems. But if you refuse to work and serve your government master, you are going to have problems. And if you're going to stop working for your government master, then you'd better know the rules. Now, I was talking about this book as I got digressing here called The Trial Judge's Manual. Now, I'm not going to sit here and read the Trial Judge's Manual to you. What I'm going to do is I just want to run through here and hit a few highlights. It's included now as a part of this tape. I would expect you to read this because there's some good information in here about which side of the judge does the American flag sit on and which side does the state of Idaho flag sit on. And where does the plaintiff sit and how does the jury come in? And all of this information is in here. I didn't say this wasn't a valuable book. I just said that judges tend to overuse it and to use it in violation of the rules. When you catch that, call them on it. But other than that, there's all kinds of nifty information in here. Let me take a look at a couple of samples of the nifty information and let's cover it. Turn over here. It's to Chapter 8, page 11. It's about halfway through the book until the bottom of the page says 811. There are no page numbers on this trial judge's manual. And you'll see 8, 9, 8, 10, 8, 11. Let's just pick one at random here where it says the payment of the fine. Now here's the judge. He's going to, or he or she is going to take a look at this and say, well, now this is what my job is. And I have to collect this fine, and so here's what I'm going to do. This judge is not going to turn to Idaho Code, which I think is Idaho Code 2822-101, where it says that the dollar is the unit of account in the state of Idaho, or Article 1, Section 10 of the Constitution. This judge is going to go to 8.71 and read on the way the judge is going to read. Fines must be paid in cash. Checks should not be accepted. After the imposition of a fine as punishment, the defendant should be accompanied by the bailiff to the clerk where the fine is paid. The court should give those unable to pay a cash fine time to cash a check or obtain a loan, and may continue the bail bond until the fine is paid. Let me ask you a question. What if you're out OR? What if you raise the money issue and you say, Your Honor, I don't have any lawful money of account in which to pay this? And Idaho Code 2822-101 says that the unit of account is $1. Now, are you going to order me to pay Federal Reserve notes or bear fat or walrus lard? What is it that you're going to demand that I pay you? You see what happens to your poor judge now? He's sitting here reading what he's supposed to read. He's unaware of the rules of procedure, the statutes of money, the Constitution, and Article 1, Section 10. He doesn't know, nor does he understand the Coinage Act of 1792. He's a magistrate. He's working in the traffic court. Nobody even comes in and pleads not guilty and demands a jury trial because he probably doesn't know how to conduct a jury trial in some cases. And here you're going in raising all these questions. He goes on, an extension of time in which to pay the fine may, as a practical matter, have to be granted. Well, now, what if you've read the trial judge's manual? And what if you're aware that as a practical matter, he has to give you more time? And he says, well, are you going to pay this fine today, Mr. Gordon? No, Your Honor. Why, I've got a big money problem here, and the money problem is Idaho Code and Article 1, Section 10. Well, then you're going to have to go to jail. Oh, wait a minute, Your Honor. If you'd check your trial judge's manual, I think that as a matter of practical fact, you should give me time with which to pay, or you should give me time with which to make my appeal. I don't think you should put me in jail, and I don't think that you should compel me to specific performance beyond the directions that you have in your trial judge's manual. You see where you got the judge? You know the rules better than he does, or at least as well as, or at least you know some of the rules. You're not a total, incompetent. You know, you've got some knowledge then, don't you? The following agreement form may be used for this purpose. Now let me show you where the courts always lay the poor citizen away. Look at this payment agreement. It says, I, George Gordon, hereby agree to pay the fine and costs assessed by the court on or before, and here's your specific agreement, and the date and the time, and I understand, you see here, here's your understanding then of the law, that failure to do so will result in a warrant being issued for my arrest and the fine and costs being served in jail at $5 per day until the fine is paid in full. And you sign it. You see your contract? Once you've signed that contract, there are no rights involved. It's a contractual agreement. I agree to pay the fine. But what happens if you don't agree to pay the fine? What happens if you don't agree to go to jail and you don't agree to pay the fine and you demand your rights and you demand that the judge order you to pay in something other than lawful money? Do you think that judge is going to sit there and order you to pay in walrus fat? Judge, I've got 3 barrels of walrus fat out here, and I'd be happy to tender those in payment of this fine. You think he's going to accept that? Well, in the state of Idaho, he's absolutely forbidden to accept anything but dollars, nor can he assess the fine in anything but dollars. I was in court not long ago, and we have a magistrate out in our traffic court, and she's a heck of a nice lady. She's a little ignorant and doesn't really know a whole lot about law and about Constitution, etc. She's very knowledgeable about the traffic court, very knowledgeable about how to accept guilty and not guilty pleas in the trial judge's manual. And I raised the money issue with her, and I didn't expect her to understand the first 10 words. When I brought up Idaho Code 2822-101, she looked over to the prosecutor as if to say, uh-oh, hey, listen, I've got to take judicial notice of this statute because it's an Idaho statute. She's sitting there saying, well, I don't have to take judicial notice of Article 1, Section 10, but what am I going to do with this state statute? And she suspended the $200 fine because of the money issue and imposed 35 days jail. Well, what is she going to do with Ardersinger versus Hamlin? She denied me counsel. Is she going to put me in jail for 35 days now since I was denied counsel? Well, if she does, she's got a Title 42 problem. You see where her problem is. You see how those rules, here's a Supreme Court case, here's an Idaho statute, and here's the judge's payment of fine from her manual. So she's going by her manual, and I'm going by the Supreme Court and the statutes. You see where you've got that judge boxed into a corner? If you assess a fine, I won't pay it, and I will not sign this contract because I don't want to. I demand to pay my debts at law, and my government illegally and unlawfully took my lawful money away in violation of my constitutional right to have gold and silver. So, through no fault of my own, I can't pay this fine, and you're going to assess this fine in Aborigine fingernail clippings. I don't have any Aborigine fingernail clippings, and I can't get any. Oh, well, if you don't pay Aborigine fingernail clippings, I'll put you in jail until you do. That's life imprisonment. Can't do that. That's ridiculous. Writ of habeas corpus comes in. Can't you imagine this? Writ of habeas corpus to the Supreme Court of the state of Idaho. Judge Schmidley over here assessed a fine in 314 pounds of Aborigine fingernail clippings and will not allow the defendant out of jail until said fine and costs are paid in full. What's the Supreme Court going to do? Probably going to fire that dumb judge. Flip over here to 915. It's at the bottom of page 99. Just flip over 3 or 4 more pages. I want to cover another interesting little item. It's just, I don't know if it's interesting to you. I told you this is a pretty dull, dry, boring, and interesting topic and subject. It seems, though, that sometimes when you get into something and you start looking and you start finding out, well, wow, these rules aren't all that big a deal. I mean, if a judge, if a magistrate judge can learn these rules, why can't a citizen? I contend I'm smarter than any magistrate in the United States. And I've told you that I'm an incompetent. I don't even understand more than 2% of the English language. And if I can do it, I think you can do it. Take a look over here at 9:15 where it says, well, it's 9:13 actually, where it says time for objections. Let's just take a look at objections and see if we can learn something about objections. An objection should be made promptly as soon as the inadmissibility of the evidence being offered becomes apparent. Yeah, I agree with that. Failure to object timely is fatal. It waives your objection. I had a judge do that one time. Watch this. I'm sitting in there, and there's all this bad evidence coming in, seeing, oh, it's irrelevant and it's immaterial. Boy, am I going to get this guy. And I'm sitting over there, and he keeps asking these questions, and I'm sitting there, off point. Gosh, boy, am I going to get him. Pretty soon he gets all through examining this guy. Objection, Your Honor. His questions are irrelevant and immaterial, and on top of that, he's leading and he's doing this, and he, And the judge leans over and he says, Mr. Gordon, why didn't you object timely? Well, I am, Your Honor, but I didn't want to interrupt him. I didn't want to be rude. Mr. Gordon, you've got a little problem here. I don't think you understand objections. You see, objections must be made, and they must be made before the witness answers the question, because now you see the witness has already answered the questions and the jury's already heard the answer. Did you think that we could tell the jury to just forget what they've heard? But we will. Well, Your Honor, You see what happens? You have to know when to object, don't you? And so, here in the trial judge's manual, it tells you when to object, doesn't it? Okay, here's a motion to strike. And here over on the other page at 9:8, it says, control of the judge over the presentation of evidence. And so you can learn what the judge is going to do pursuant to the presentation of evidence. Motion to strike. Time for objections. Turn the page. Hearing counsel on objections. Deferred rulings on objections. The effect of general objection. What is a general objection and what is a specific objection? How do you use them? Let's go right into the judge's chambers and let's ask the judge's trial handbook, shall we? You've got it, and I don't care whether you're in Florida or Georgia or where you are. What you're seeing in here, remember, comes from judges and lawyers. And the information in here is good general information. It's not the law, but it's good general information. Now remember, the reason it's not the law is because it's not the rules. And there's a big difference between the administrative procedures of the jail and the Constitution of the United States. But nevertheless, wouldn't it be of great advantage to you if you knew the administrative procedures of the jail? Boy, when I was out there, I scoffed up their administrative procedures manual. I did it right away, and I read it. I know the procedures of the jail better than the jailers. When I walk into the jail, I know exactly what's expected of me and what's demanded of me. I know what is constitutional and what isn't constitutional before I walk in. You know, it's like going into a game, and I know all the answers. How would you like to get on the $64,000 question? And before you went in to answer the questions, you had the whole list of questions and answers, and you sat there and you briefed yourself and memorized them all. And you walk in there and they say, what are the mating habits of the aboriginal tsetse fly of the Belgian Congo, of the Ituri rainforest of the Belgian Congo? The mating habits of the tsetse fly of the Ituri rainforest differs just a little bit from the mating habits of the tsetse fly of South Africa, in that the gestation period is 6 weeks and 1 day versus 6 weeks and 4 days. You know, I mean, here's this, crazy question and this impossible answer, and here you are in the courtroom and you've got the answer. You're in the jail and you know the answer before you ever ask the question. How's that? The jailer says he wants your fingerprints, and you say, wait a minute, why do you want my fingerprints? Well, because it's the law. Law? Do you have the law? Let me see the law. And they fumble around, and, well, there is no law. And so they're fumbling around, and they're trying to, where's the statute? And they can't find it. Let me ask you a question. Could it be under Idaho Code 1948, 12, and 13, which is the administrative procedures of the law enforcement growth industry of the state, or the law enforcement agencies of the state? And this jailer went in and he told the lieutenant, yeah, that's right, and this law says that you have to give us your fingerprints. Let me take a look at that law, son. And I sat there and I pointed out to him, I said, now, if you have the fingerprints of the subject within 1 year of the date of the arrest, then it isn't necessary to take his prints again. Let me ask you a question here, Mr. Jailer. Do you have my prints in here within the last year? No, we don't have. Haven't you ever seen me in here before? Well, yeah, Mr. Gordon, we've seen you in here several times. Okay. Don't you have the records right back there in your cabinet, back there, file cabinet, and don't you have that kind of stuff? Why don't you just run back there and check? I think on March 24th, 1982, Judge Schmidley over here ordered me to give you my prints, and I did, under threat, duress, and coercion, in violation of my rights, give you those prints under court order. And that protected me and my Fifth Amendment rights. And I'm telling you that pursuant to Davis versus Mississippi, you need a court order. Now, you don't need the court order because you've already got the prints, but in the event that you do want to take them again, I'll give you these prints every hour on the hour for as long as I'm in this jail. And I'll help you take the prints. I will roll the ink out for you. But I'm demanding that you get a court order pursuant to Davis versus Mississippi, which is the law of the land. I just want you to obey the law, Officer Schmidley. Now, do you understand that? I'm not obstructing and delaying you. I want you to obey the law. Poor Schmidley, he never could understand. I read him the statute, and he couldn't understand. I told him to go look it up in the file cabinet under G for Gordon, and I spelled my name. It's Gordon. And he came back with, but the Administrative and Procedures Manual says I have to take everybody's fingerprint. You know, that's why he's a jailer. And that's why he works for government. Because he's incompetent and couldn't function outside of government. And you have to understand that. These people have the mentality of slaves because they are slaves. Okay? So you've got a slave on the plantation and you're expecting him to do something, to understand something, to perform in a capacity for which he has no understanding. So understand and realize that when you're dealing with your public servants, they are public servants because they fit the definition of a servant. And servants aren't masters. Now, masters are the owners of the company. I used to run a pretty good-sized company. When I operated that pretty good-sized company, I knew pretty much all of the rules, all of the procedures, all of the laws, all of the information I needed to make my company run. But I didn't expect the forklift driver to know and understand the Interstate Commerce Commission rules pursuant to furniture in interstate commerce between New Mexico and Texas. And I wouldn't even ask the poor guy a question like that. He couldn't function there. I had to function there. I had to know the law. I had to know how to move furniture from New Mexico to Texas. But the forklift driver didn't need to know that. And so the poor forklift driver, all he's competent to do is to say, you got it on the wrong size pallet and it won't fit on the truck that way. Now there's his position. So when that jailer sits there and says, the book says to take your prints, don't get mad at the poor guy. He doesn't understand the law. Just get his name, just get his rank, just get his admissions and confessions, and then you sue him later under Title 42. That's the way to handle him. If he violates your rights, let's take him for some money. Let the county pay for his mistakes. And that's the way you handle that. But in order to handle that, friends, you have to know the rules. You now have all the rules, okay? They're right in front of you. And in 3 hours, I cannot read all the rules to you, now can I? But I think in this lesson I've told you how to look the rules up, what to look for. If it says you shall do this, then you can be pretty well sure that it says you better do that. If it doesn't say, don't assume what it doesn't say. You don't have to specifically perform what it doesn't claim, what it doesn't command. All right? You see that your constitutions are the paramount and superior laws of the land, and that the constitutions are reinforced then by these legal quotations, of which you just have a smattering. I think you've got 300 legal quotations there. Those legal quotations are the law of the land. You can't be compelled to give up one right for another. You can't compel me to give up my Fifth Amendment right, protection of my fingerprints, for the right to get out of the jail and to exercise life, liberty, and property. Don't expect the forklift driver or the jailer to know and understand that. You need to know and understand that. And the more of those Supreme Court cases you read, the more knowledgeable you will be in law. All right, then just to recapitulate for a moment, your trial judge's manual, while it's not law, it's just chock full of all of the information and nifty little rules and the way the court's going to work from the judge's perspective. You then know all that the judge knows, plus all that you know. Now, you've got your state constitution. You need to learn, know, and understand it. Don't worry about those sections of your state constitution about education and school lands. It's not relevant to you, unless you're going to challenge the school lands or something like that. But you do want to know what your rights are, and that's up here on your Declaration of Rights. Okay? So you want to know that. The rules of criminal procedure. You need your state's rules of criminal procedure, your state's rules of civil procedure, and your state's misdemeanor rules. And your state's, or your district, or in our county right here, we're in the 4th Judicial District. You need those rules. Don't memorize them. It isn't necessary. The rules are simply laid out just like a dictionary or an encyclopedia. You just look up the word or the definition or the title that you want, and it's 2 or 3 pages long, and there's the rules. You don't do any more than it says. You don't do any less than it says. When it says you will motion it up, and don't bellyache. If you don't put the paper in, don't expect the results. It's just that simple. So there you have rules. The rules are the way the game's played. When you play the game by your rules, your chances of winning are 100%. When you play the game by their rules, your chances of winning are 0. So it's up to you to play the game and play the game by your rules.